o'clock. We had a FFA breakfast this morning. I didn't want to deter from those kids in the blue jackets, which is very important to the state of Georgia and agriculture. Danny, would you ask a prayer for this crowd, please?
Yes, sir. Let us pray. Father, we thank you for this morning. We thank you for the folks that are here. We ask that you would bless this committee. Let us do the things that are wise and pleasing to you. In Christ's name we pray. Amen.
Thank you, sir. We have a new member, Mr. Joe Campbell from Camilla. Used to be with Birdsong Peanut. Is that right? No, Golden. Okay. Excuse me. I apologize for that. I knew it was one of them peanut companies. But welcome to your ag committee and your capital, and we looking for great things from both of y'all, two new ones there. Also, our intern, Nathan, was it a four-wheeler wreck, correct, Lee? He had a pretty bad four-wheeler wreck over the weekend and was pretty bad beat up, but he got out of Grady last night. And so we all need to think about him today, and he'll be okay. He's a pretty tough guy, one of them Marine types. And anyway, he had a pretty rough weekend. Today, the only thing we are doing is House Bill 847. John Corbett has a patience way beyond what Job had.
Be careful not to pray for patience.
He is, yeah. He has been even keeled for the last 2 years. We have had meetings on top of meetings, and every time we'd agree on something, somebody would find some little insignificant something in this bill that might not suit. We are finally, hopefully, at a point where we can pass this out, because I'm telling y'all, it is crunch time in Georgia. We should have had this done several months ago. The greenhouse people are getting antsy. The farmers are getting antsy. Gary and them are going to start issuing processor permits in about a week and a half. And processor permits aren't worth a whole lot if you hadn't got somebody growing what they want to process in the state of Georgia. And the whole emphasis of this bill is to provide the citizens of Georgia a quality product that you know what you're getting, and not something you buy at the car wash that came from who knows where. So it is crunch time. We need to get this out, get it to the Senate, and if there's something needs tweaking, we can tweak it in the Senate. But we don't need to be holding this bill in the House any longer. So without any other from me, Chairman Corbett, thank you for your patience, thank you for your diligence, and thank you to everybody that has had input into this. So we hope we are at a point that we can do something with this. It's time.
Well, thank you, Mr. Chairman, members of the committee. I bring before you today House Bill 847, LC 441414S. House Bill 847 is a cleanup bill from last year's House Bill 213, the Hemp Farming Act. The USDA did not come out with their rules and regs till late last year. So part of this bill is to get us in compliance with their rules and regs so we can get approval to start issuing permits and license. Another part of the bill, we need to clarify the ability of a greenhouse grower to be able to grow the plants and sell it to a farmer. We left that out last year. We're going to clarify that. And then we needed to clarify for the college and universities. They had some issues. We thought we had it where they could conduct research with third parties. But anyway, working with UGA and the other colleges, they needed some other language put in the bill to clarify that where they can contract with third parties and processors and growers. So we've got that in the bill. We need to clarify, what code section the violations and violators would be covered under. We've got that in the bill. And then at the request of the processors, some processors that's actually in the business located here in Georgia, they wanted to codify the transportation piece of it. This is coming from people that's in the industry. That way, They know what they have to have when they're transporting it in the state, out of state. They know what they need with that load, where they'll be in compliance, where it's not up to interpretation by whoever stops them. It'll be in code. So that was at the request of the industry. We did that. A couple things I'd like to talk about before we get into the bill. You hear the word, it's about hemp going hot, and that automatically people think, well, it's marijuana. But to be hemp, it's got to be 0.3% THC or less. Anything over 0.3 is considered marijuana. And probably, I'd say 95% of the hemp, when you say it goes hot, it's probably less than 1%. Marijuana that they're growing today is anywhere from 18 to 25% and higher, and law enforcement can verify that. So when we say hemp goes hot, it's still a long way from being marijuana. Second thing I would like to say is, if we were dealing with pepper, squash, blueberries, or eggplant, we wouldn't even be having this conversation. But we're dealing with a crop that just by minute change in the THC content, it can be from a legal crop to a illegal crop. So we've got to have very strict rules and regulations on who, where, how, and when, who can grow it and process it, where it can be grown and processed, how it's transported, and when it's tested. Very strict rules and regulations just for that fact. Like I say, if it was blueberries or eggplants or squash, we wouldn't be having this conversation, but it's not. And so we've got to have very strict rules and regs. USDA has over 160 pages of rules and regs. Georgia Department of Ag, Bryce in here, I think we've got 63 or 66 pages of rules and regs, just Georgia rules and regs. So it's a very strict control crop, and it has to be. So now let's get into the bill. Like I say, LC 441414S. All right, lines 14. Basically, we're changing the definition to align with the federal definition to comply with the USDA's rules and regs. Line 17, just added the word permitted to cover processors here. Same thing on lines 20, we added to cover processors, and it also adds colleges to be able to conduct research there. And that's all colleges and universities, not just university systems of Georgia. So not just land grant. That covers them all, and that was at the request of our university systems to put that in there. Lines 32 through 35 basically excludes the biomass from being a legal hemp product. On lines 32 through 35, lines 36 through 42, and again, this is to comply with USDA rules, just defines key participants, who, and later in the bill, who has to have a background check and fingerprints, but that defines key participant. Lines 36 through 42, again, defines key, I'm repeating myself. Lines 50 through 51, excludes merely placing the raw dried biomass in a container and calling that processing. 64 through 65 allows a college or university to provide hemp to a processor for research. 66 through 72 allows a licensee to sell hemp to another licensee. Basically, that covers the greenhouse grower, where they can grow the plant and then sell it to a farmer under a license. That covers the part we left out last year. And then also allows a college or university and to provide it to a college or university, and allows for a grower to sell to a processor in another state as long as that state has a plan that's been approved by the USDA. And that was 66 through 72. Lines 75 through 80. That covers the punishment for the violators in Code 1613-30. And just to clear it up, the original bill from last year provided that if you do not have a license or a permit, you could not have hemp in your possession, and it was punishable under Title 16. What we're doing here is actually adding a code section where it gives the prosecuting attorneys some leadway under how they prosecute that, whether it's a misdemeanor or a felony or whatever. It gives them leadway on how they prosecute that. And while we're on that, talking about hemp is not a controlled substance, and therefore it is not subject to the civil forfeiture laws. Under 1630-49, it is not subject to civil forfeiture. I want to repeat that, and I can have prosecuting attorney's counsel verify that and give us all the code sections for that.
Say that one more time.
Hemp is not a controlled substance, and therefore not subject to civil forfeiture laws. And we, like I said, I can have the prosecuting attorney's counsel come up and verify that. Sir? Yes. All right, lines 81 through 91 allows colleges with the University System of Georgia to conduct on-farm research. This is on varieties and how it grows and where it grows. So that's college with USGA, and it allows them to contract with a third party to do the on-farm research. 96 through 98, basically it's a greenhouse grower does not have to have a contract with a processor to be able to get a license. So a greenhouse grower does not have to have a contract like a grower that's growing it to sell. He has to have a contract with a processor. The greenhouse grower does not, because he's selling it to another licensee. Lines 102 102 to 116 basically deals with the background checks, when you have to have them, and then covers the fingerprinting for licensees. Lines 121 through 135 does the same thing for the permittees or processors, the background checks and fingerprints. Line 144 through 181 here again deals with the transportation of hemp, and this was at the request of processors in the state, where they wanted everything spelled out that load would have to have with it. And I also talked with a friend of mine that's in the trucking industry, and basically any load that you don't have a bill of lading with, they have the Department of Transportation, under federal rules, they can stop you, and you've got to produce that bill of lading. They can hold you there until you produce that, ever how long that takes. So that's nothing different having to have a bill of lading with the shipment you have. 186 through 208 deals with the collection and sampling and the destruction of hemp or hemp products that exceed the federally defined THC level. And then lines 210 through 212, let me get to it. It deals with any THC that is collected in the processing, any excess THC, how that will be destroyed. That's what lines 210 through 212 covers, and that's going to be rules that's promulgated by the department. Then lines 220 through 229, basically it just says the department shall comply with all federal inspection, reporting, auditing requirements. Basically we're doing there. And that's basically the changes we made to the bill, Mr. Chairman. And if any questions, or if we want to go ahead and have the prosecuting attorney's counsel come up and talk about the civil forfeiture, hemp, how that doesn't apply to hemp, if that's the pleasure of the committee.
Thank you, Mr. Chairman. Why don't you let them come on and explain that, and it may cut down on some questions.
All right. Thank you, Mr. Chairman.
But you don't go anywhere.
Thank you, Mr. Chairman.
Thank y'all. I know y'all have put in a lot of hours on this too, so.
Well, we're trying to make sure we work with the committee and with the chairman here to make sure that this is a bill that the state can be proud of. With me is Gilbert Crosby. Mr. Crosby is our subject matter expert, so if you ask me a question, I may turn to him and have him. My name, for those of you who don't know, is Pete Scandalakis, and I'm the executive director for the Prosecuting Attorneys Council. And while we're talking about hemp, when you look at the civil forfeiture statute that Georgia has under 1613-49, it specifically says that The statute covers controlled substances, raw materials, or controlled substances analogs that have been manufactured, distributed, dispensed, possessed, or acquired in violation of this Article 16-1349. Since hemp is no longer considered by the federal government as a controlled substance, 16-1349 would not control. And anyone seeking advice from the Prosecuting Attorney's Council, we would tell them the same thing, that if this is a hemp product, it is not subject to asset forfeiture under 16-1349. If there's a problem with, let's just say, a truck full of hemp, that would again go to the Agriculture Department, would not come through the Prosecuting Attorney's Council or the prosecutors.
All right, would you take a question?
Yes, sir.
Is 23, is that you, Emery? Yes. Is your question for them? Okay.
Thank you, Mr. Chairman. Let me ask you a question. You were talking about, and I understand the exempt or regulated part of this. The bill of lading has to state it's one or the other. Exempt means it's a raw product, and if it's regulated, it is a finished product. When the hemp leaves, is it considered exempt or regulated?
I would say, sir, as long as it's a hemp or a hemp product, it would be something that's exempt. It's not covered by the criminal barriers against marijuana and against controlled substances. If there was an issue with that, a substance, either you're talking raw hemp from a grower or a finished product from a processor, that, you know, it was just, we're dealing with issues of documentation. That is the sort of thing that, from my understanding of the bill, and I believe Carson's as well, would be covered by the Department of Agriculture's regulations. If there was an issue there, that's where that issue would be resolved.
Okay, thank you.
Who's 29? Scott?
Thank you, Mr. Chairman. I appreciate the comments and the effort to make sure that we're not subjecting hemp to civil asset forfeiture and looking at 16-1349 that's not controlled. But my concern with that is that we start treating in this bill hemp under 16-1330, which the very first line of that says purchase, possession, manufacture, distribution, or sale of controlled substances or marijuana penalties. And so if we're not treating it for civil asset forfeiture, why are we treating it for criminal purposes as if it were marijuana?
Well, now you're talking about the difference between a misdemeanor amount and a felony amount. I imagine that's what you're trying to get to, Representative Turner.
Well, I'm looking at line 77 of the bill. It says violations of subsection A. It doesn't, and subsection A doesn't mention quantities, and neither does 16-1330 for that matter.
Just very briefly, Representative Turner, 16-1330J covers basically the full range of penalties ranging from misdemeanor to felony amounts. It references other statutes such as 16-13-2. Referencing that, and that just deals with individuals who are knowingly violating this provision by not having either transporting it without proper authorization to do so, or transporting substances that are not legal will be covered by that code section.
Okay.
And one thing we have to be careful of is when we're talking about hemp, we're talking about obviously the product that has 0.3% THC or less. So when you get into a large amount that's over an ounce, obviously if it tests greater than 0.3%, if it tests 0.18%, then you've got marijuana. I mean, it's clearly marijuana, and marijuana continues to be illegal in Georgia. And then that comes under a different, that would be punished as if it were marijuana.
So, but we would be treating those cases less than, was it 30 grams? I think is the threshold.
28 grams.
28 grams. GBI has put a policy in place. They're not testing less than 30 grams. That's where I get the.
Correct. Yes, sir.
So they do have the test available to them should they choose to. Some jurisdictions, like my own, have contracted with private entities. Is that a recommendation the Prosecuting Attorney's Council based upon?
No, sir, we do not have that type of recommendation. That's not a recommendation I would make to this
So
body.
would you say it's fair to say that prosecuting attorneys throughout Georgia do not always follow the recommendations of the Prosecuting Attorney's Council?
Well, we don't go into how you're going to, what law enforcement agency, what they're going to use to test the product. So that's not something I'm comfortable testifying to.
So my concern is you started out the testimony by pointing out that civil asset forfeiture wouldn't apply here based upon your recommendation. However, there is a huge incentive for local law enforcement and DAs to ignore that type of recommendation because they get 100% of the proceeds.
Well, no, sir, because what we're talking about, again, if you're talking about a civil asset forfeiture and you're talking about a crop that is greater than 0.3% THC, that's illegal in the state of Georgia. That's marijuana.
Sure.
Okay, so that's what we're talking about.
I'm talking about hemp.
We're not talking about stopping some truck on the side of the road that has a bill of lading and has hemp in it, because that would come under the agriculture department.
So,
And I don't know if I'm addressing your question directly, but you know, we need to distinguish: are we talking about hemp, or are we talking about what is illegal in the state of Georgia, which is marijuana?
well, I think that's great because I agree with you. We're talking about two separate concepts here, and I think sometimes we get confused that hemp is marijuana, and I know that you don't, but sometimes folks get confused. Hemp, marijuana, it looks the same, it must be the same. I gave everybody an apple today. I can't call that an orange. You know, they're two separate things. Even if I were to pass a law to call it an orange, it's still an apple. You know, the laws of nature still apply. It's a different product.
I wish we were talking about apples and oranges. I wish we were talking about blueberries, eggplants, and squash, as the chairman said. But what we're talking about is whether or not it's 0.3% greater or not.
So are you aware of some of the things that have gone on around the country since, and this might be a better question for the author of the bill as well, but anybody can choose to answer. Some of the things that are going around as far as Commerce Clause implications relating to the transport from one state to the other across states where they have requirements like a bill of lading or other documentation or permits. And we have determined in our previous hearing that there are states all around us that have legal hemp. They may not have the same requirements for transport that we do. But there have been states that have seized hemp, legal hemp, from states grown like in Colorado, where it's also legal in Oregon, and they travel across Idaho where it's not, and they ended up in a civil asset forfeiture proceeding. Are you familiar with that type of case?
I'm familiar with one case that occurred, but I'm not familiar with all those cases, no, sir.
Okay. So this is something I continue to have a concern with, because when it comes to civil asset forfeiture, as you know, I've seen you guys make recommendations, the Prosecuting Attorney's Council, and then prosecutors say, well, we found a different way to do this. And they remain incentivized with 100% of the seized assets going to fund their own departments. And so whether or not, because of the evidentiary standard is so low when it comes to civil asset forfeiture, that they don't have to prove very much in order to associate it with a crime. And so I'm not 100% confident that that would be the case. That's more of a statement than a question. But more, in Section 6, which is different, we're just seeing this today for the first time. So I apologize for going through this. Section 6 says that in this term, it should not include any part of the plant of the genus cannabis except for the completely defoliated mature stalks of plant, fiber produced from such stalks, or completely sterilized seeds.
Representative Turner, which line are you reading?
Oh, I'm sorry.
We
Looking
haven't seen
at Section 6 starts at line 29. It goes through line 35.
Okay.
And in the previous version of the bill, and you can address this if you don't know, it's fine. In the previous, it talks about derivatives of the hemp plant. So we are seeing all kinds of products with CBD oil, which are derivative of hemp, being sold in the marketplace legally because of the farm bill that was passed federally. Things like lotions, hair products, toothpaste even. All these things contain a derivative of hemp. Would that be included in this definition?
If you read right before that, Scott, any federally legal product is legal under that, except for the biomass. Anything that is federally legal except the biomass.
So that was...
That's the only thing
me find my previous version of the bill there. So in subsection 5, lines 25 and 28, hemp means the cannabis sativa plant, any part of such plant, including the seeds thereof and all derivatives. So would that be in violation of the federal law then? Are we creating a conflict? Because this very clearly says in 26, and that's current code, that derivatives like CBD oil would be illegal under this bill. Well, there are attorneys in the room that are texting me telling me that's the way they read it. You know, the most dangerous thing that happens around here is when two attorneys disagree on something. So I think it does include derivatives like CBD oil. And I think that's probably enough of a concern for us to take a deeper dive look at it. But there are other problems with the bill, and I've taken up a lot of time right now, so I want to give somebody else a chance.
Thank you, Mr. Chairman. I just want to, I kind of forgot what I was going to ask. It was so long. But I'm sorry. No, it doesn't. I got an email regarding this legislation. And the author of the email was concerned about the making portions of this bill legalized because it make it difficult for law enforcement to test the THC levels in the hemp. And I was just trying to figure out, did anyone else get those emails?
Miss Patty, I got a boatload of them last night, and they were all from lawyers that never showed up during all these meetings we have had.
Okay.
And then all of a sudden, everything's wrong.
Ma'am, if I can attempt to address your question.
Please, thank you. Thank you, Mr. Chairman.
The concern about there are issues with distinguishing THC levels. There is no, right now available in Georgia, there is no regular, affordable, easily accessible test that distinguishes. This bill actually, in its current form, actually does address those concerns where hemp is illegally possessed by somebody who does not have a permit, that it is treated under this, who doesn't have a permit or a license or is not properly transporting hemp, and understanding with the rules about documentation that there will be a clear way for legal participants to establish that. This bill does actually is designed to hopefully give prosecutors tools where those, where people are not in compliance with statute, are not farmers, processors following the rules. There is a tool that we can use.
Very good. So, okay, that helps me. Thank you. Thank you, Mr. Chairman.
So pretty much, if it's in a baggie under your front seat and you don't have a license, I'd lean toward marijuana. If it's a semi-load in the back and you got a license and a bill of lading, it's probably hemp. Is that kind of the way we're looking?
That's pretty much. I mean, that would be the quick and dirty version of it.
Okay.
So, yes. I mean, there would be a. There's, like I said, Department of Agriculture will have documentation that can be established that will clear up, that will avoid the concerns Representative Turner raised about, the issues where someone is driving through. But I think this bill, as I read it, creates the space for the legal processors to be able to display that when they encounter law enforcement.
If you got the paperwork, you're okay on anything. Matthew?
Thank you, Mr. Chairman. Mr. Crosby, are you a scientist?
No, sir.
Okay, so this may not be appropriately addressed to you, and if not, forgive me. But first of all, let me just say that I appreciate the author's work on this bill and the committee's work, Mr. Chairman, to make sure that we get it right, because I know that there are some civil liberties concerns and concerns of overregulation. So I think it's important that we take our time and get this right. My question for really anyone is, what is the harm of possessing less than 28 grams of hemp? What is the harm to the individual or to society?
I don't know the answer to that, but of course, as from a prosecution standpoint, from a law enforcement, the problem is, since we don't have a test now, an affordable test for those field officers who come across less than 28 grams, you can't distinguish between marijuana and hemp, okay? So the content of that green leafy substance could be 0.20%, okay? And since we can't test that, affordable test right now, if you treat less than 28 grams of any leafy substance as hemp, you're decriminalizing marijuana in the state. And I don't think that's what the legislature wants at this point, or the governor. But that is a policy question for y'all. We're just out in the field trying to enforce the laws that you create.
I appreciate that, Mr. Scandalakis, and I think that's my concern here, is that we are, we're presented with this issue of there is no, I think, Mr. Crosby, you said no regular, affordable, or easily accessible test available to law enforcement on the scene to test the THC level. But my concern is, so to fix that issue, we're going to create a brand new crime for possession of a substance that the federal government has legalized and has said is not a controlled substance.
I see what you're saying.
Thank you, Mr. Chairman.
Dominic?
Thank you, Mr. Chairman, and thank you both for coming and being with us this morning. And one of my favorite movies is My Cousin Vinny. And there's some debate about whether or not the witnesses are experts or just kind of have some country boy knowledge of what's going on, but I would consider you two to be experts and have a comprehensive and authoritative knowledge of what we're talking about. And I heard the chairman say 5 times about civil asset forfeiture. So my 2 questions are just going to be old country boy yes or no questions. Is hemp, as defined by federal and state of Georgia, is it a controlled substance, yes or no?
No, sir.
And if it's not a controlled substance, is it subject to civil asset forfeiture?
No, sir.
Thank you, Mr. Chairman.
All right, Scott, real quick, please, sir.
I can't make no promises, Mr. Chairman. Last year, there was a federal case that stayed the state of Indiana's ban on smokable hemp. Are you familiar with that?
No, sir.
There's a federal case, in case you want to go look it up, or anybody in the office does. It was CY Wholesale Incorporated versus Eric Holcomb, governor in his official capacity. Federal judge ruled that because the smokable hemp was a legal federal product, that Indiana's ban on it was unconstitutional. How do you see this particular effort to treat hemp, or less than an ounce, as a criminal action standing up to federal scrutiny?
Mr. Turner, I'd have to look at that law and research it, and
Fair enough.
I'm just not prepared to answer your question. I'm sorry about that.
No, that's fair enough. I think that's one of the reasons why we have hearings, is so that we can discover and go and research and find the answers to these questions. So I appreciate the honesty. You mentioned in your testimony as well that there's no affordable test, yet the GBI testified last time there is a test and it costs $80. Is that what the test that you're referring to as being too expensive?
Well, I'm not sure. I'm not sure about that. I don't know how much it costs, but I know when you start getting into just in the metro area alone, testing thousands and thousands of less than an ounce small baggies, that would be expensive.
So why couldn't we just?
I think when you say it's $80 a test, I'm not sure how much it cost the GBI for the equipment that they purchased. Oh.
Just kind of real quick on the testing. As far as it being affordable, the issue is that just the level of sophistication that's required in the test, we have not identified anything that local officers can do in the field. So it has to be done in a lab setting. And because, as we all know, because you can't distinguish it by the naked eye, we need to determine that purity. We're only able to do it in the lab. There have been companies that claim that they can do it, but when we do our internal studies on it, it's still not acceptable. So right now, there's just not a test out there that local officers can utilize. And so the language that's in this law basically will bring back that ability for the local officers to do that. So when they're stopped, they'll be able to make that determination and then bring it to the lab. So right now, we have come up with testing to be able to distinguish it because we're in that crime lab setting. And so we're doing 30 grams or more, the felony amounts basically because of resources. We have not tested marijuana in over 20 years because we have a local testing program to do that. And so we want to be able to focus on the other higher penalties like heroin, meth, and all these other controlled substances that are out there.
So thank you for that. I appreciate it. The previous representative for the GBI in our previous committee hearing did mention that there was a test available that we could reproduce at $80 per test. So that you're saying that is either unreliable or just not. What exactly? I'm not going to put words in your mouth. What's your reaction to that?
Well, so initially when they were looking at those studies, they found that if they can simulate something, that they would be able to do that. But it would have to go through a lot of testing and have to be approved by in the courts and all of that. So they just did not view it as a feasible option.
This comes down to I think one of our founding principles, and that's burden of proof. Whenever the government accuses somebody, it's their job to prove that somebody's actually committed a crime. In this particular case, we're taking a product that's federally legal and that we would like to see legal in Georgia, and we're treating it as if it were a criminal product. We have the ability to do a test. We are choosing not to because of either the number of people, number of cases, or because of the cost. Why couldn't we, and this could be to anybody, why couldn't we, if there was somebody that was actually in possession of marijuana, the orange in this case, not the apple, why couldn't we just, in that criminal prosecution, make the defendant pay for the test if they're found guilty?
Because if the defendant's indigent, why would we put that burden on an indigent defendant?
So then we're talking about making a law that would be so broad to catch everybody for carrying what would otherwise be a legal product because some folks wouldn't be able to afford the fine of the crime? Is that the logic?
No, sir. I'm just answering your question. I'm just,
yeah.
The difficulty, again, when you're talking about marijuana and hemp, is it's almost indistinguishable in the content. That's what you're talking about. And you're talking about someone who has a license or a permit and someone who doesn't. And I see your concern, but from a law enforcement standpoint, we're looking at it as how do we enforce the statutes that y'all pass?
Right, and so we have the tools that are out there to distinguish the difference. And our burden of proof relies on us in the government whenever we accuse somebody of a crime. Why aren't we just taking the steps necessary to establish the actual criminal behavior on a product that is actually illegal?
I just don't know how to answer that question.
Well, okay, fair enough. It remains an outstanding concern for me that we're taking an apple and we're calling it an orange, and then we're trying to prosecute the possession of oranges when we in fact have apples. This is, with the ability out there that we can distinguish the difference. So that continues to be an issue. But my last point, Mr. Chairman, and I promise I'll be quiet unless somebody says something that makes me want to talk again. On May 28th, the USDA issued a memo establishing the authority of the states to regulate the production but not the transport of marijuana. Or not marijuana, I'm sorry, I'm talking about the apples, of hemp. It specifically states that we may not prohibit as a state the interstate transport or shipment of hemp lawfully produced under the 2014 or the 2018 Farm Bill. By requiring documentation that other states may not require, will we run up against some sort of enforcement problems with that?
I don't believe so. We're not prohibiting it. We're just putting regulations on it, which every state does. So I don't believe that would be contrary.
So if a truck driver from Florida is passing through on his way to Tennessee for a processor and he has a big load of this stuff and it's not defoliated, it's got the leafy material, and he doesn't have proper paperwork, and he gets pulled over, we're not prohibiting him from traveling through the state?
Well, again, I'm not familiar with all the regulations that are required to transport products through Georgia, so I can't answer that question.
Thank you. I appreciate the transparency. Mr. Chairman, I'd love to make a motion at the appropriate time.
All right, hang on a minute. For those of us that hadn't been in meetings with you, ma'am, would you tell us who you are and who you work for, please?
I'm sorry. My name is Nellie Miles. I'm the Public Affairs Director for the GBI. I did spend my first 16 years in forensic chemistry.
Thank you, ma'am. All right, Patty,
Thank you, Mr.
do
Chairman.
you remember now?
I remember now, because Ms. Nellie has affiliation with Fort Valley State University, so that's what my question is relating to, the university part of this bill. To the author of the bill, institutions like Fort Valley, and maybe someone in the audience is here representing the University System of Georgia, are these institutions now, has the University System of Georgia given the institutions the kind of the green light to move on the research of this? Because there seems to be no activity right now with Fort Valley State University, and I need to have a better understanding of why that's the case. Thank you.
Yes, thank you. This bill clears up all the concerns the colleges had. Last year, UGA did some research on campus in 3 different locations. Fort Valley, had the opportunity to do that as well, but I don't know for what reason they didn't, but they had the authority. But then UGA, their issue was on farm research. They didn't feel like they could, unless somebody had a permit or a license, that they could not contract with them. This bill clears that up, and it also clears up any other university can conduct research on uses of the product. But in Fort Valley and UGA, we're doing the research on the growing the varieties and how and when to grow it. So
Okay.
This does give them full authority to move forward.
All righty. I just trying to figure out how to ensure that message really makes its way down to the administration of the university, because there seems to be no activity right now at Fort Valley. And every response I get is, we're waiting on the university system to give us some direction.
And Chairman will recall, and it was in Perry a year ago, we met with Fort Valley and UGA at Perry and talked about their concerns, and this bill addresses all those.
Okay, very good. And one last thing, Mr. Chairman. Back to the license for transporting hemp and all those other requirements. Just some way to make absolutely sure that local law enforcement is really knowledgeable all this, and I support local law enforcement all across the state, but just some way making sure that these farmers that are working hard to just make a living and doing the right thing legally are not having to spend half of the day on the side of the road trying to explain to a police officer that may have been on the force for 20 years that this is legal hemp that they're transporting. So if there's some way to make sure, I don't know if there's anyone in the audience affiliated with these police departments, associations, to make sure that they are truly understanding what this law means and knowing all the aspects of it. That's my point. But thank you. That's my last comment.
Yeah, absolutely. And if they've got the proper paperwork with them, just like the farmer can't transport it off the farm until it comes back with a certified test that it's below the 0.3. So as long as he's got that documentation with him, then transporting it to the processor. So that it will give him what he needs. And I think the Sheriff's Association, I know in their conference they have every year, they talked about this extensively. I've talked to my local sheriffs, and they've been updated on it. Now, maybe need to do a better job with some city police departments, maybe, and we can work on that.
A vault crew was this weekend trying to explain that they were getting ready to dig a grave on the side of the road, explaining to a police officer. I had to throw that in for the funeral homes part.
Just to briefly,
Yeah.
Once there's a clear understanding of what documentation can be expected, we can make law enforcement know in concert with sheriffs and chiefs of police, so that the law enforcement is made aware of what to expect to see when someone is transporting that, so that in those situations where that occurs, because our concern is not the folks who are attempting to comply with the law by getting licenses. Right. Our concern is the folks who are using and distributing illegal psychoactive marijuana for the purpose that it gets used, who are trying to use, facets of what's known in our circles as the hemp defense as a cover.
Right. Just like complained that they were going to a funeral. They had to spend most of the time on the side of the road. I'm waiting for them at the cemetery. So I don't want to see a farmer having to go through same thing my vault company had to go through this weekend. That's it for me.
Thank you, ma'am. There's a couple of three folks want to talk, quickly, I hope. Maisie Lynn Causey. Yes, sir. And then Rob and Thomas, if y'all will kind of get ready.
Good morning, sir. Thank you so much. My name is Maisie Lynn Causey. I represent the Georgia Association of Criminal Defense Lawyers. And I've heard you loud and clear, sir. You've spent enough time with lawyers lately, but I appreciate you accommodating my request to talk. I know we are not typically before your committee, but we feel like this is incredibly important. And to Representative Wilson's point, we believe that what's happening here is the criminalization of a legal substance. That this bill, the criminal aspects of this bill, are seeking to criminalize a legal substance of hemp as if it were marijuana. And we've discussed in several contexts this morning how how hemp is not a controlled substance. It's not something that needs to be controlled. It's not even psychoactive. There's no reason for you to be criminalizing hemp with this bill in the way that it does. I will go through the lines in order just to try to stay on track and be quick. We do believe that in lines 25 through 28, the definition of hemp as it stands today does include products like CBD oil, which of course today is not a problem because hemp is legal. But under this bill, with hemp becoming essentially marijuana, the CBD oil is implicated in these criminal infractions. We have a suggestion, if you would be willing to take it, regarding the definition at lines 32 through 35, just in hopes of streamlining that because of the language around the shall not and the exception. I won't read that to you now, but I will hand you a copy before I go in case you'd like to consider it. If you move down to line 75, which is on page 3, line 75 is part of subsection A of 223.4. It's A6, wherein any licensee or permittee to otherwise fail to comply with the requirements of this chapter or any applicable state or federal law or regulation. We just would like to draw your attention to the breadth of that statement and the potential number of laws that could be violated or regulations that could be violated without any nexus at all to hemp or marijuana, but to hemp in this case. And our suggestion would be that you just leave paragraph 6 as it is and strike the inserted language on line 75 because of just the sheer breadth of that particular statement. And then I would draw your attention to lines, this is I'm sorry, I am working from 1414S, lines 76 and 77, as well as 78 through 81. So this is where hemp becomes marijuana for all practical purposes in prosecutions. What is interesting even about what's here already is that in line 76 and 77, and I'm getting a little bit in the weeds, but I think these technical issues are worth noting. 76 and 77 grab all of subsection A of 223.4. Subsection A includes 7 different paragraphs. When you go down to lines 78 through 81, that also grabs 2 of the paragraphs in subsection A. So essentially, when you take 76 through 81 in total, there are 2 different penalties for 2 of those paragraphs. It's just unclear to us which one actually would control. And because of our strong concerns around criminalizing hemp as if it were marijuana, if you are inclined to do this, we have a suggestion that you instead make this a civil penalty. Within Title II, you already have a civil penalty structure in place. So we do have some language where you could bring that similar language into this bill and prevent this from becoming a prosecution that would result in jail or probation or punishment of that type, and instead make it a civil penalty in line with the other enforcement that happens under Title II. And finally, Two additional points. One is that in lines 78 and 79, as drafted, this idea of a culpable mental state greater than negligence is just not something we typically see in the criminal law. There is a similar culpable mental state within child cruelty statutes, but generally speaking, we find that criminal prosecutions happen because someone knowingly intends to act in a certain way. And so if that's the desire here, that might be in keeping with the language that we're used to seeing in the criminal code, a change in the culpable mental state here, unless it is meant to be something less than knowingly. And I guess that's just would be a broader conversation we'd potentially need to have with the sponsor and legislative council. And finally, it's been mentioned, and it was just mentioned at the close of the sponsor's comments, that there is testing that's happening. The department is testing crops for the THC level. We know the testing can happen. It may not be able to happen on the side of the road, in the field, as we would call it, but it can happen. We've heard in earlier hearings, as Representative Turner mentioned today, it's about $80 a test. It is available to the GBI. They have promulgated some procedures around how and whether they're going to be testing. So while we understand that it may be costly, taking someone's liberty, putting them behind bars, restraining their very person, it costs money to do that. And we just believe that if the tests are available, they should use them. They have the ability right now to prosecute marijuana. They have the ability right now to run these tests, and as does the Department of Agriculture. So we know that that's available. There's no reason to criminalize hemp in this way. It's simply a benign substance that does not need regulation of this type. And I would stand for questions if you have any.
Thank you, Mr. Chairman, and thank you for your testimony. I'm going to try to ask a lawyer question.
Sure.
The best I can.
It's fine.
Writing a check, if you have money in the bank, is not a crime.
Right.
But if I steal someone's check and forge it, that's criminally prosecuted?
It is.
I think there seems to be some, or maybe I'm the one misunderstanding, that what we're criminalizing is not hemp. It's breaking the rules. We're setting the rules. You should go to jail. Or they hire somebody like you to come and explain why they should not go to jail. I don't think, in Kansas, hemp grows, they call it ditchweed. Pull over, pull it up, smoke all you want, and haul it. But if you break the rules that are set by the legislature, you've committed a crime. So to hear people continually say that we're somehow criminalizing hemp, I think is and again, maybe it's me that don't understand, that's unfair.
And maybe it's an inartful term on my part, and I will own that. Because as it stands right here today, you can prosecute someone for breaking these rules. You can. If someone is not a licensee or a permittee, you have already built in a structure within your bill, within the existing code, to capture that disobedience and punish it. You can. So the distinction here is, to do that today, you have to, the law enforcement agencies involved, in this case usually the GBI, I mean in our state that's who's doing the forensic testing of substances, just simply has to do that test and decide if the violation is a violation simply regarding hemp because it falls under the threshold of 0.3% THC, or if it rises to the level of marijuana. And then they are handled differently under the law today. If it is hemp and someone is violating because they're not a licensee or a permittee and they are transporting or possessing hemp in an improper way, it's handled under Title II, and it is a misdemeanor. There are enforcement provisions in place. To bring it into basically the sort of the controlled substance aspect of our code, which is what this bill does by bringing it into 161330. The only way to do that is to know that it's marijuana. So the issue is, it's a crime right now. You're right. It is a crime right now for someone to mishandle hemp. This is just taking steps. This is changing the penalty, making it a much harsher penalty for both marijuana and hemp than it is today. Simply because, from our perspective, the GBI doesn't want to run these tests on small levels of marijuana, on small levels of hemp, to determine what the substance is.
If they have the proper paperwork, you don't need a test.
Unless
And
you
so
s-
follow the
sorry.
rules, get your proper paperwork, no need for a test. Now, if someone's just haphazardly riding around with a baggie full of hemp, why, I don't know, because it does them absolutely no good, and you don't have the proper paperwork, you go to jail. I have a little plastic card that'll get me in that Capitol. I walk through there without that card, there's a good chance they'll frisk me or put me in jail, whatever. There just seems to be some problem with people following the rules. And I'm sorry, but I'm still missing that because the lawyer language kind of confuses me. But we're just saying follow the rules. Need no test. You get caught without the proper paperwork, you're going to need more than a test.
I hear your point, sir. There's still an issue of distinction between what the substance is and what it's not, even with the paperwork.
The paperwork distinguishes that.
Thank you. With the expanded definition of hemp and hemp products on lines 30-ish, 29 through 37-ish, we're making hemp a controlled substance. Is that right?
It's now going to be prosecuted as though it were.
So
Yes, sir.
the concept that was brought to us earlier, this is a major concern of mine, and it has not been addressed during this committee, is that by treating hemp as if it were marijuana, we're subjecting it to the same standards of a controlled substance.
So I've heard your concern today, and I would have to look a little more closely to know with any certainty about the implications of civil asset forfeiture. But certainly what this bill does is it treats hemp as marijuana for the purposes of prosecution under Title 16.
-30. Yeah.
And I raise the distinction and my hesitance around, a certainty around the civil asset forfeiture because, when you do look to the definitions within Title 16 that are at, while I find my reference. I believe it's 1621. Sorry, 161321, as well as 161325. 161321, paragraph 16, in the definition of marijuana, which is under the controlled substances portion of that title, it does exclude hemp and hemp products.
But if I'm not taking the time to tell the difference between a hemp product and a marijuana product, and I'm just going to prosecute everything as if it's marijuana, it would be subject to civil asset forfeiture.
I certainly think it opens the door to that. I mean, I think this is just another place where there's going to be a required test, because in order to proceed in civil asset forfeiture, you're right, it does have to involve a controlled substance. So I think then the burden is still going to be on the state to prove that it is a controlled substance for which they are taking someone's property. Their testing is going to have to happen.
But in common sense, like Dominic said, if you have the paperwork, then it's probably hemp. If you do not have the paperwork, it may be hemp or it may be marijuana, but you are not following the law of the state of Georgia.
Well, sir, if I could respectfully, when you look to Title II, 23(4), subsection A, paragraph 7. One of the things that the bill currently disallows is for a retail establishment to sell the flowers and, I'm not going to get the language right, but the flowers of hemp, essentially. Because that's been happening. And so that is something that has been circumscribed as should not happen. So we know that's happening. We know that you're asking that it not happen, but because that's happening, it is possible that someone is holding hemp without a bill of lading. And it really is just hemp. And now why someone would do that, I don't know. Because like I've said, there is no psychoactive effect of that product. But we know in other states, it's been mentioned today, people are using smokable hemp. There are reasons that maybe defy our thinking about why someone would have hemp in their possession without a bill of lading, but it is possible. And at this point in time, now that person is going to be punished as if it's marijuana because of the refusal to test, an $80 test, as far as I understand it from the GBI.
If it came down to me going to jail or me paying $80 to get a test done, I think I'd find somebody that would do the test and give them $80 to prove what I had,
I can't disagree with you on that. So.
whether the state proved it or not.
Well, except that the Constitution does require the state to bear that burden.
I understand that,
Yes, sir.
but I'm talking common sense. If it's to where I'm either going to jail or not, I think I'd come up with $80 and get a test done.
I hear your point, but unfortunately, that's not the way our system is set up.
I still understand that, but if it's between me going to jail.
Yes, sir. I hear you. I hear you.
All right, I don't see any more red lights are flashing.
Thank you, sir.
Thank you, ma'am.
I appreciate your time.
your time. Robert Thomas, whoever wants to go first.
My name is Rob Lee. I'm with Georgia Extracts, a hemp company here in Georgia. Chairman McCall, Chairman Corbett, committee members. I wanted to bring to everyone just a few comments from the industry. So I've been involved with this legislation since we actually started back in 2017. So I've been here somehow. I've participated in the study committee and meetings and all of this stuff. I wanted to let everyone know I've not only participated here at the state, I've talked to the University of Georgia for multiple years. I've met with Fort Valley multiple times. They've come up to a tour at our facility. I showed them around Athens. We went down there and talked to them. I've been to DC. I've met with USDA, the people who run the hemp program. We've met with ONDCP, the White House, House Ag, Senate, Congressman, everybody that we have possibly could think of that we could meet with concerning hemp. And I want you guys to understand this industry is crazy. It is emerging. It's brand new. All of your questions are 100% legitimate. But we came to the state and we have talked to everyone about building real companies who want to comply with the law. And we want to follow the rules, and it is regulated. And we only touch industrial hemp. We prefer 0 THC, but we want it all to be under 0.3% THC. We're not medical marijuana. We're not talking about that. We're not marijuana at all. It's only industrial hemp. And so what I wanted you guys to hear from us is it's time to go. And so I understand we need to get this right, and we have trusted you guys. We've actually invested about $5 million in our facility here in Georgia. Many of you have been on tours to this facility, and I would invite anyone, you can come and see what a real facility looks like. You can see 50 cameras across our facility with access control, and it's monitored, and it's stored in the cloud, and there's video. You can see my testing equipment, a $1.5 million worth of testing equipment, so that the tests that the GBI is talking about, we can actually perform. But here are some of my issues. I can't start the business really running until we get this thing going. Everyone I have talked to, from you guys to the governor to DC, we understand we want an industry here, and consumers are demanding it. What is happening right now in Georgia, and this is my passion about this industry, is products are being sold in Georgia that are not safe. For our company, our slogan, pure, tested, and proving, We believe that more than anything. We've tested over 100 products that are sold in Georgia stores. Over 44% of those products are not labeled correctly. They have no CBD in them. They don't follow the labels. And until we start this industry here, consumers in Georgia are going to continue to purchase unsafe products. Now, we're going to have to figure this out together. But I want you guys to know that there are people like us in the industry who are going to do this right. We're going to make Georgia proud, and we're going to build a great industry in hemp here. And we're out here doing this even as you guys are putting this together. And so for some of this testing, I want to address that specifically. So we bought all of this equipment so that we could test the products that we were making because we thought it was the right thing to do. If people are going to consume CBD products or other products coming from the hemp plant, we should test it ourselves. Whether you guys require it or not, we should test it. Well, guess what happened? Law enforcement found out we had all this equipment. I've had probably 15 sheriff's associations come through our facility and look at our testing equipment. We have the machine. GBI was at my facility last night looking at our testing equipment. But I can't start this business yet because we don't know how we're going to do the industry here. So we are going to offer testing. The Commissioner Black knows about the testing facility, and Bryce and Department of Ag here. Hopefully we can offer those services, but it is out there. But until it gets going, companies like ours can't stand up and build these facilities. They're very, very expensive to get going. We've taken the risk because I trusted all of you guys and I've been involved in the process. If we don't move forward, I'm going to have to move to another state, I guess. But we want to do this here in Georgia. We're Georgia people. And so, yes, in terms of the testing, if businesses like ours can test, whether it's marijuana or not, we're going to get a DEA Class 1 license. We've already submitted our application. It supposedly takes about 6 weeks. We could test industrial hemp or marijuana. The test runs between $75 and $150. It's the same equipment that GBI uses, and that's the cost of it. It will be easily done. Field testing, this is a new industry. We're working with a company, we're working with the University of Georgia to try to do new technology that will do it. We have possession, you can come to my facility and see it, instrumentation called near infrared technology. You put a sample on a tray, it spins around. In 15 seconds, it tells you the amount of CBD and the amount of THC, but it's not very accurate. Right? We think it's about 80% accurate right now. We need over 2,000 samples. One of the projects we're talking to with UGA, who we can't work with right now, is to build an algorithm to make this thing accurate. Sheriff's Association said, hey guys, could you build mobile labs that could come to a location and test this within an hour and a half? So we just want to know what it is. All this is going to come. And there are going to be companies like ours who step up, and universities like here in Georgia that are going to do this research, and it's going to be amazing. And so I just wanted you guys to hear from someone in the industry who is passionate about this. We're building a great company, and there is all of these things that are going to happen. It may not be there today, but it will be there in the future because the consumer demand for these products is massive. People want them, the farmers want to grow it, and we're going to be able to do this right.
Scott, real quick, we're getting close to time to start session, and I don't want Mr. Joe to miss his first day of session because he's sitting in an ag committee meeting. Go ahead.
Sure.
Would you consider hemp and hemp products to be the same?
Hemp and hemp products, yes, I hope they're the same.
Okay, and then lastly, you said just now that you have a field test, it's like 80%.
Again, it's a machine test, not a field test.
Sure.
So it's a $40,000 piece of equipment, very expensive, very accurate, but again, there needs to be more research on it.
A new squad car costs more than that.
Correct.
So one of the points that Chairman Corbett made when he introduced the bill to the committee earlier was that modern marijuana is in the 20% or more. I forget the exact number. I want to 18 to 25%. THC and the THC level in hemp is 0.3. Well, that's a massive difference when we're talking about percentages. So when you say 80%, if a marijuana is hot and is in that 18% range, how confident are you in the test that can be easily proven with one of these tests?
That is correct. The only issue here is that because of the federal definition, the 0.3% becomes very critical. For farmers and things like that, when it goes hot, that's why the machine has to be so incredibly accurate. But yes, if it's 5%, even 1%, the machine is accurate enough to tell what that is.
One of our big concerns in the legislature has been medical cannabis and CBD oil that has a certain percentage of THC or less. And so what you're telling me is that because of the differences between hemp and marijuana, one of these tests can very easily determine the difference between these two products. Is that what I'm hearing?
The lower price machine is not as accurate, but yes, it can tell the difference. The machines that we use to run ours, high performance liquid chromatography, is accurate enough to be used in court.
Thank you, sir.
All right, Thomas.
Thank you, Mr. Chairman. I'll be
Thank you,
brief
Rob.
since I know we're under a little bit of a time crunch here. First of all, I want to thank Chairman Corbett for his leadership and diligence on this. My name's Thomas Farmer. I'm a co-founder of Second Century Ag, a processing plant that will hopefully be licensed and up and running in the great city of Osceola, Georgia here very shortly. Rob has, I think, very eloquently put into words a lot of kind of our feelings about being processors in this state. We're spending a lot of time, a lot of money, and we feel like, you know, this is a great economic development opportunity, particularly for rural Georgia. I want to bring up 2 points. First and foremost, my partners and I grew 108 acres of hemp in Tennessee last year and very much understand the rigors of growing the crop. But really what I wanted to bring to point is I've also had the experience of transporting that crop in an unprocessed state to North Carolina and to Colorado. And I can tell you that Tennessee's transportation rules are very similar to Georgia, to what is being proposed here. I'm not sure about all the states between here and Colorado, but I can tell you that if you follow the rules and you label every sack that was in that semi, you have the bill of lading, you have the license for the place it's going, the license from the place that you sent it from, you're going to be all right. Perhaps you avoid Idaho, that's fine. But I think, you know, the USDA has very specifically said, and I think this is going to be backed up by, you know, the highest court in the land, that interstate commerce prevails here. I'm not worried about that part of this at all. I think this bill addresses that just in a fine manner. So again, I think the other piece I want to say is the way that the bill is structured here, the processors are very much tied to the farmers, and that's probably a good thing, at least in the beginning. We need to be able to work together. This is not an easy crop to grow; it's an expensive crop to grow, but time is of the essence. Decisions, as the chairman pointed out at the top of the hearing, decisions are being made on what to plant. They're probably being made on what to plant months ago. So we are really hoping that we can get this thing done, and so that we can not only process, but we can work with those, especially in the South Georgia community where we will be, on helping those farmers grow. So I will stop there, but thank you for the opportunity, and we look forward to hopefully getting this thing moving. Thank you, Mr. Chairman.
Thank you, Thomas. Dominic, you got a question?
Mr. Chairman, thank you. I'm convinced. I've followed this from the beginning, and every stakeholder and every person in these committees have done their dead level best to make this right. The chairman has worked 24 hours a day, but Mr. Chairman, I'd like to make a motion to pass.
All right, we got a motion and a second. All in favor say aye. Aye. Opposed, no? No. Are y'all satisfied, or you want a hand count?
Satisfied.
Mr. Chairman, just for the sake of rules, in the event that we want to issue a minority report from those who voted no, can we just get a total count of no votes?
I think it was two, wasn't it?
Fair enough.
Was it any more than Scott and Matthew that voted no?
You might help me a little bit.
Absolutely, sir. And I don't know what you do with a minority report other than give it to me or something. I don't know, but Anyway, thank everybody for your participation. I appreciate it. Thank you.